Good afternoon, everyone. Welcome to the malpractice session. My name is Salman Al-Sabah. I'm the chair of the session. And please, we look forward for great speeches today. Today we're going to focus on malpractice in surgery, bariatric surgery. And it's given me an honor to introduce our moderators. We have Dr. Nicola Persa from Italy and Professor Scott Shikora from the USA. The first speaker is Professor Henry Buchwald from the USA, and Professor Henry is a well-known figure in the field of surgery and bariatric surgery. So without further ado, I'd like Professor Henry, please go ahead.
All hear me. How's that in the back? All right? Okay. I'm going to give you the history of metabolic, or not metabolic, it's for metabolic surgery, but medical liability in the metabolic surgery field. Where did it come from and where is it heading? Now, what is medical liability? It originates in the law. And the law is based on communities, religions, nations, and empires. And there are unwritten laws, and you cannot really trace them through history. But there are written laws, and we're going to look at some of them to see where we came from in terms of our current litigation. Now, one has to discriminate between criminal liability, which has to be initiated by a federal, state, or local law enforcement. And if you have a conviction, you're subject to monetary fine and incarceration or loss of citizen rights. Now, okay. There's a civil liability, which is called a tort. Can be initiated by any citizen as long as it obeys the rules of the court. And conviction here can only be financial. But you can have a tort that then is converted to a criminal case. Now, historically, there was corporal punishment in addition, and this was ordered on conviction for criminal and civil liability. So let's look at history. In 2100 BC, there was the law of Ur-Nama, of the Sumerian kingdom of Ur. And in this law, there was Rule 13. If a man is accused of sorcery, he must undergo ordeal by water. If he is proven innocent, sinks. As you lower him into a tub of water, his accuser must pay him 3 shekels. Well, this same technique was used in the Winston-Salem witch trials in the United States. And so if you were innocent, you sank because the water, which was holy, did not reject you. But if you were innocent and you sank, you drowned. So you didn't really lose, you didn't really win either way. And this law was reinforced by his nephew in 1994 BC. Now, most people quote as the start of medical liability the 1794 law of Hammurabi inscribed on these stone pillars. And he had 282 laws, and 215 to 223 were all dedicated to medical malpractice. Now, Rule 218 says, if a physician performs an operation and kills someone or cuts out his eye, the doctor's hand shall be cut off. There was no trial, no presumption of innocence. Now, from about 2700 BC onward, there are many hieroglyphic writings cumulative in Egyptian papyruses that refer to bad medical outcomes against the standard of care. So the introduction of the concept of standard of care goes back to Egypt. But what was the standard of care? It's what the royal physician priesthood said it was. 1500 BC, the Indian laws of punishment. There were very severe laws for malpractice, but it was modified by caste. Therefore, if you were a high caste Indian, you didn't have to worry about it. If you were a low caste Indian, you had to worry about it. 1200 BC to 195 BC, the law of Moses, the Old Testament. There is nothing really in there, but there is no admonition against the tort for medical negligence or harm, but there's no specific reference to it. The law that is usually stated as the origin of Western law is the Roman Lex Aquila, 283 to 476 AD. And it's the model that many have adopted in Western society. And it clearly distinguished between willful harm and negligence. In 476 BC, there were the Chinese Confucians' precepts of the Tao. The Tao was doing the right thing, doing the good thing. And if you didn't have the Tao, you shouldn't be a doctor. And that was the malpractice of the age. 1206, 1227, the reign of Genghis Khan, who ruled the largest land empire ever in the history of the world. And his transgressions were against the Tao. If you weren't doing the right thing. Now, this could mean stealing a loaf of bread, killing a horse, whatever it was. If you were doing the wrong thing and not the right thing, you were convicted. But it was interestingly, you were convicted by a trial. So trial came in under Genghis Khan. But then if you were convicted, there was only one thing to do, and that was death. Medical liability in Germany. Now we're going up to 1532, the reign of Charles V. Unkunft was the term introduced for medical misconduct. In the Carolina Code, strict and specific rules for torts to distinguish not meeting medical standards from carelessness and neglect. And in 1811, there was a famous case where there was one doctor versus another doctor. And this case went on to be converted from a tort to a criminal case, and the plaintiff lost and the defendant doctor won. But it made a very famous case in German law. 1932, 1945, German doctors violated all precepts of malpractice, liability, and decency. This period and these doctors brought eternal shame and infamy on the 5,000-year history of the medical profession. There were the Nuremberg trials, and they prosecuted 23 leading German physicians. 16 were found guilty, and 7 were sentenced to death. 1937, 1945, Japanese Unit 731, Harbin, Manchuria, China. Japanese doctors experimented on prisoners of war and civilians, inoculating them with diseases, as well as rape-induced pregnancy studied by vivisection. Again, these violations of medical liability brought eternal shame and infamy on the medical profession. But here, unlike in Germany, General Douglas MacArthur excused the entire unit for their data. Now comes some fun stuff. Medical liability in the United Kingdom, 1767, Slater versus Baker and Stapleton, established the rule of medical expert witnesses. And that's another thing that has carried over. And for medical liability suits, but they could only be due under contractual law. There was not negligence. You had to have a contract So if the doctor said, I'm going to save your life or your wife's life, and he didn't, that was breaking the contract. And in 1932, there was the case of Donahue versus Stevens, which was decided by the House of a house in England. And the plaintiff Donahue filed a tort against the purveyors of a bottle of ginger beer because she found a decomposed snail in the bottle. And the verdict established the principle of torts for harm away from contractual relationships. So it took till 1932 to break the contractual rule. In 1957, the Bolam test ruled in favor of the doctor in a hip fracture suffered during electroshock therapy. The Bolam test established a rule that the doctor did not have to warn the patient of specific risks before a procedure. No informed consent. That was the rule of law. 2015, look how late, 2015. Montgomery versus Lancashire Health Board reversed the Bolam law and established that doctors had a duty to advise patients beforehand of the possible risks of a procedure. Medical liability in the United States, 1794, plaintiff sued a surgeon for his wife's death for not fulfilling his contractual promise to perform a skillful and safe operation. He was awarded 40 English pounds. 1935, 1965, malpractice crisis, because there were a lot of amputations instead of efforts at repair of limbs. And this is interesting, 1836, 1846, Abraham Lincoln was a prominent malpractice lawyer for plaintiffs. 1847, the AMA founded and set standards for the standard of care. 1960, there was again an upswing because there was new technology and new malpractice insurance. And in 1984, there was the famous Libby Zion death case in New York, which established the hours a resident can work. Medical liability in the United States is part of accidents as the third leading cause of death. That's pre-COVID. In 2019, there were 59,813 malpractice suits filed in the USA, and that was the high point. And the basis for a malpractice suit in the United States is the legal duty of the doctor to provide care or treatment, breach of that duty by violation of standard of care, causal relationship of breach and injury to the patient, so the two have to be related, and most important, damage emerging from the injury sustained. So in other words, if there's no damage, there is no tort that would be approved. Now, there have been 3 sensational cases in the United States. 1997, Julie Andrews, who's probably well known to all of us, who made her living with her singing voice, went to Mount Sinai Hospital in New York and had a bad operation on her vocal cords, and she lost her singing voice. She sued the hospital. A settlement was made. We don't know the amount. In 2000 is a real weird case. A Dr. Alan Zarkin, a successful and competent obstetrician, performed a C-section, and he was so proud of his work, he took a scalpel and he carved his initials onto the patient's abdomen 3 inches high. Well, he lost the lawsuit, and it cost $1.75 million. In 2005, there was another very famous lawsuit, and I won't go through the details, but the award that was ruled by the jury was the largest ever, $216.8 million. So, where do we go from here? This is where we've been. Where do we go? What are we doing now? Well, there's effort at tort reform, and the purpose is to limit healthcare costs and increase healthcare benefit for the majority of the nation's citizens. The movement started in the 1970s. It is a state function in the United States. 30 states have enacted tort reform laws. It's not a federal function. The advocates are, of course, physicians, other healthcare workers, hospitals, and malpractice insurance companies. The opponents are most lawyers, specifically malpractice litigators, and most people in Congress because they're lawyers. Tort reform laws, what do they hope to do? Cap claims for economic and punitive damages, in particular for emotional pain and suffering. So a wife can't sue for loss of consort because her husband had a bad operation. Capping total plaintiff awards, shortening statutes of limitation, limiting attorney contingency fees, protecting malpractice insurance limits from disclosure. In other words, a good plaintiff lawyer can go shopping if he knew how much this person could get and how much this person could get. And limiting forum shopping. Well, we don't want to go to this judge, he doesn't like plaintiffs, and we want to go to this judge, he likes plaintiffs. And those are the objectives of tort reform. Achieved benefits. We've seen decreases in malpractice litigation in many states, decreases in medical malpractice insurance rates, decreases in costs and procedures in defensive medical practice, which has come into vogue. You know, let's get this x-ray so we won't be sued. And that's going down. Decreases in court and jury time and expenses, and potentially reversing the decrease in physicians and healthcare workers by increasing profession attraction and making medicine and healthcare once again a profession and not a business and not a risk but a calling. Paul Gauguin, in his last great painting, in the islands in his little hut before he died, painted this beautiful picture on the wall, and he labeled it, "Where do we come from?" And I've tried to show you that. What are we? And I've tried to show you that. And where are we going? I have no idea. Thank you so much.
Thank you, Dr. Buchwald, for an excellent presentation.
We're not going to have questions now, are we? No.
No, at the end.
Okay.
Thank you very much again for the excellent presentation.
I'd like to invite the next speaker to come up, Dina Carroll, to talk about medical liability in Italy, working through the malpractice process.
Good afternoon. The subject of my speech evokes the theme of the CD medical malpractice, a theme of strong media impact, which deserves a more careful reflection and more rigorous interpretation. I thought it appropriate to verify what is a deep personal conviction gained during my professional experience. The spread of a phenomenon of unfounded complaints that was found were spread in our country, especially in the 90s and the early 2000s. The future for the reference period are surprising. 40 doctors reported every day. Every Italian doctor has, in 20 years of activity, 80% of probability of having to face a process. Only 25% cases of professional misconduct are convicted, and 3 out of 4 doctors are acquitted. Very few then, in proportion, the judgment that come to the scrutiny of the Court of Cassation. This is an absolute importance and in some respect very comforting for the citizen because it shows that the Italian medical class as a whole has a high degree of preparation. On the other hand, the phenomenon of spreading unfounded complaints it is asserting, then end up producing considerable personal costs due to the serious damage to the margin and the consequence on personal balance or on the existing level unjustly persecuted professional. More, in our penal system, when a complaint is filed for medical fault, due to the practice, the public prosecutor tend to enter in the register of suspects all the doctor listed in the medical record sites. This to prevent the first investigation and, therefore, also the autopsy are not usable against some sanitary that then turn out to be guilty. The excessive number of criminal complaints had led to another consequence, the use of so-called defense in medicine. The doctor concerned to be subject to a criminal trial often leads to health, or to prescribe visit, examination, and treatment not strictly necessary in the specific case, positive defense medicine, or to avoid patients or high-risk treatments adopting a stationist attitude, negative defensive medicine. One wonders what are the cases of such high number of complaints and trial against healthcare workers, and such a large number of acquitals. I would be inclined to believe that there is a marked speculative component, an attempt to exploit the prosecution to obtain substantial compensation, in the belief that the criminal process can be more immediate and effective answer than the exercise of the action in civil. I believe, however, that this speculative intent fails to explain the scale of the phenomenon. There is a more subtle, profound reason for modern man's present attitude towards illness and death. From the total absence of death by primitive culture, we have passed to a pervasive and subtle refuse to die. In this way, the conviction has been rooted that medicine cannot but must abolish suffering and in the prospective death. It has been forgotten that the activity of the healthcare provider is a means and not a result. Grounding in the collective consensus of this misconception gives patients and the member of their family a sense of revenge in the event of a failure to heal or death. In my opinion, this is the reason for the large number of unfounded complaints. Given this premise on the genesis of the phenomenon, I would like to move on to address the evolution in Italy of the criminal trial for medical responsibility, starting from the analysis of the conditions for the affirmation of a criminal responsibility. Criminal liability presupposes the violation of a criminal precept. Normally, the legislator expresses judgment value and criminally sanctions those behaviors that attack the legal goods, that in certain historical period are considered worthy and aids of protection. The doctor of professional responsibility involves, indeed, a number of numerous crimes, but the two most recurrent indictments in a judicial case of the professional responsibility of the doctor are represented by manslaughter and negligent injury. We can say that in order for the criminal responsibility of healthcare to arise in addition to the error of diagnosis and therapy, two other essential elements are required. There must be a causal link between the technical error and the harmful or lethal event. It's also necessary for the behavior of the doctor to be characterized by psychological element of guilt. The error might result from omission of the hospital or improper action and may depend on inexperience, carelessness, or negligence, or violations of rules, regulations, and disciplines. The issue of medical guilt has been subject to considerable differences of interpretation and has been the subject of various regulatory interventions. Starting from a unitary criterion of the concept of guilt, inferable from all the rules of the legal system, valid for both civil and criminal law, much of the doctrine and case law have been made applicable also in the criminal field, the principle contained in Article 2236 of the Civil Code, which regulates liability for professional negligence in cases where it's necessary to address the resolution of technical problems or particular difficulties, and dictates the rule of judgment according to which the person is liable only if he has acted with the intent or gross negligence. For a long time, therefore, the work of the doctor was evaluated only in cases of gross technical errors, and conformed the judges to the criterion of gross negligence. With the evolution of medical science, and above all, with the introduction of the constitutional charters, which expressly provide for the protection and safeguarding of primary goods, such as life and health, this principle of grave guilty has gradually climbed. A thesis has taken shape that has argued that the norm of which to Article 2236 of the Civil Code is an exceptional norm, which derogates from the normal criteria for assessing liability for fault, and therefore cannot be applied behind the mandatory cases for which it has been expressly provided. This rule, therefore, would not apply in the assessment of a criminal liability. And indeed, with the recognition of the assets, life and health at the constitutional level, the jurisdiction has attributed to the doctor a function of guarantee with the correlative obligation to do everything that science suggests to ensure the patient's health. The analysis carried out so far clearly shows an extremely rigorous trend in the assessment of guilt in medical activity. The jurisprudential contrast and the excessive rigor of some interpretation have made to warn the requirement of the participation of the legislator. In 2012, came into force the law Balduzzi, with which it was expected that the practitioner of the health profession who, in carrying out his activity, adheres to the guidelines and good practice accredited by the scientific community, does not respond criminally for the slight fall. Therefore, the law in question excluded liability for slight negligence in the case of compliance with the guidelines and best practice accredited by the scientific community. It did not, however, specify what those guidelines were. Therefore, the best known definition of the guidelines, namely the American Institute of Medicine, was used. On the assumption that the law of 2012 did not bring significant improvements, in 2017, a further legislative amendment took place in the matter. The law Gelli Bianco came into force, which introduced innovation aimed at trying to balance the risk to the health with the right of the doctor to be able to carry out his professional activity with serenity in the exclusive interest of the patient. In the criminal field, the most important novelty is represented by the introduction in the code of Article 596. Therefore, the Institute of Health has been entrusted with the task of declaring what are the guidelines, the observance of which is obligatory for the doctor in order to be able to invoke the case of no publication. As noted by the doctrine, the precise identification of what are the guidelines on the one hand, met the needs of certainty not guaranteed by the Balduzzi law, but on the other hand, risks leading to the affirmation of state medicine to the detriment of patients themselves. Based on my experience in medical fault trials, the real important novelty introduced with this latest law is represented by the obligation to always appoint in the judgments of health responsibility a college at least to consult, a medical examiner and a medical practitioner specializing in the subject matter of the proceeding. When I started dealing with medical misconduct in the late 19th, the public prosecutor office used to appoint only a coroner, who as such had not direct practical experience, but only theoretical knowledge. This meant that medical staff were often referred back to court. I must say that since the public prosecutor's office has been appointing the specialist at the beginning of the stage of the procedure, in one to the coroner, the processes that are already defined in the investigation phase with the measure of achieving are considerably increased. In conclusion, the different jurisprudential orientation that have occurred over time and the last two regulatory changes within a few years are indicative of how the issue of medical guilt is a perennial topic in our country and still has not found a definitive resolution. I believe that the approach to complaints of medical misconduct must be one of extreme caution to avoid bringing to the attention of the criminal magistrate events that should find their epilogue in the civil headquarters. It would, however, be good practice before filing a complaint for a medical fault to submit medical records and all medical documentation available to a medical examiner and a specialist in the field in which damage would have occurred to carry out a preliminary assessment of the existence of criminal liability profiles. We should never forget the essentiality of the work of health professionals and how patient care needs a serene approach by the doctor, who should have as their only concern to make the best choice for the patient, free from any conditioning or fear. Thank you.
To discuss all the papers at the end. So, Dr. John Morton from USA will give lessons learned from the ASBMBS Closed Claims Registry.
Well, thank you, Dr. Saba and Dr. Basso and Dr. Shakur. It's an honor to be here in Naples and IFSO to present this first report from the ASBMBS Closed Claims Registry. So those are my disclosures. We all know that we want to improve health care, and one way to do that is to decrease any sort of patient safety events. Sometimes, as we've pointed out today, medical malpractice may be a method to identify some of those opportunities for improvement. We all know bariatric surgery's had a tremendous improvement in outcomes. We had a mortality rate 1 out of 100, and now it's about 1 out of 1,000, so a tenfold increase in patient safety. The other thing is that we wanted to take a closer look, and this is the publication that came out last year, and honored that among the group of authors there, I think there was a total of 7 past presidents of the American Society for Metabolic and Bariatric Surgery. And I'll share with you what we did with this closed claims project. So what we did is we went to some of the major malpractice firms in the United States, the insurance companies, and there were 4 of them. So we were able to get roughly about 70% of all the medical malpractice claims in the United States. They didn't allow us to take the data out of their institution. We had to go visit them and get the data in person. And these are some of the things that we abstracted from the data that they had, some of the demographics of both surgeon as well as patients. And then we did an assessment, and this is where the authors were very, very helpful. The authors were able to assess if they thought the care was appropriate or if there was opportunities for improvement. And we also looked at a grading of complications, if they were preventable, and if there were factors that might have influenced some of these complications, like language. The United States, our slogan is E pluribus unum, out of many one, so there are a lot of different languages that come out in the course of taking care of patients. Obviously informed consent, fatigue, distraction, any sort of trainee issues, all of those were looked at. And these are how the cause determinations were graded: if it was not preventable, if the care was appropriate, if there were human error, risk behavior, and inappropriate or severe preventable care or reckless disregard. Here are the results. We had a total of 175 patients. Pretty average looking bariatric population, age in the mid-40s, BMIs getting a little closer to a BMI of 50. In fact, about 40% of those patients had BMIs greater than 50. A little bit less than normal females. It's usually 80%, and here's about 70. Most of the data predated the advent of the sleeve, so most of the cases that we had were around the gastric bypass, which was the most prevalent procedure for quite some time. And we looked again at some of the surgeon demographics, how many were board certified, and a telling note is how many of the hospitals were accredited. Nationwide, roughly about 90% of hospitals in the United States are accredited. So only about 43% were accredited that had malpractice lawsuits. So I think there's a lesson in that perhaps accreditation helps. These are some of the results. The number one reason people were sued was because of mortality, followed by leak and bowel obstruction, perforation. One that is becoming increasingly more, we are updating this particular study, but one of the things that is increasing is nutritional deficiencies, and really want to sound the alarm around thiamine deficiency. That has now become the second leading cause of lawsuits in the United States. It's unfortunate to hear bariatric surgeons say they weren't aware that could be a potential complication. So please, always keep in the back of your mind if someone's got thiamine deficiency. Nystagmus is the first physical sign. If someone can't walk, they're not malingering, they may end up having thiamine deficiency. These are the awards, about $300,000. A third of that generally went to the lawyers. Here are some of the results as to what happened. The diagnostic events weren't that common, but of the ones that were related to diagnoses, a third of them were, or about a quarter, were due to misdiagnoses. These are some of the different treatment events, and you can see there that most of them were delayed treatment. That was a recurrent theme. It was obvious people knew there was something going on, but they delayed either getting a confirmatory diagnostic test or going to the operating room, but it was pretty evident that delay in treatment is what led to many of these issues. Complication preventable by surgeon, the consensus from the group was a little over half could have been prevented. Better preoperative care doesn't look like it played a role here in most of these cases. It seems like a lot of the preparation was appropriate. Better post-op care was an opportunity for improvement. Again, the biggest issue was delay in care. We saw numerous examples of where someone else was covering for the surgeon. And one thing to get across is if you're covering for someone else, you're really covering for yourself. And you should care for that patient with the same level of regard as you would for your own patient. Factors contributing to complication I've already highlighted, which is around coverage and handoffs. Handoffs are a key aspect of patient safety. We cannot be on call all the time, so inevitably somebody will cover for us, but you should be formal in your handoffs, something that is written or in the electronic medical record. Clinical performance issues, again, the big one was the delay in treatment. Delay in diagnosis was the second leading one. Communication issues came up repeatedly. There were communication issues with the team. People weren't sure that a test had been done or it had been ordered. Communication with the family became evident in some of the notes that we reviewed, where patients' families weren't seen by the surgeon or the covering surgeon. We found that in some of the nurses' notes. So obviously, I think one of the big things you can do to help prevent lawsuits is to communicate with the patient and the family. Complications are going to happen. If you're not having complications, you're not operating. So at some point or another, you have to be able to talk to those patients. At Yale, we have something called Clear Coaches. We actually train people in how to communicate with the individual family members, and we do it as a team. So if there's an anesthetic event, it's not just the anesthesiologist, the surgeon goes out there with them as well. And we have found that that decreases the risk of lawsuits by about half. When we looked at the cause determination, it was not insubstantial, those related to either system or disease. That was roughly about a third, but the majority were provider related. And if we look at some of the issues that came up here, most of them were either human error or not preventable, but we did find some at-risk behavior and inappropriate severe care, and those were essentially dereliction of duty, where there was no coverage for patients, or there were procedures that were being done that had no antecedent. These were procedures that none of the reviewing faculty were aware of, things like massive small bowel resections for weight loss. That literally was a few of these cases. So there were some really strange results. The other thing that was telling was that there was a couple of surgeons that went from hospital to hospital to hospital and continue to have the same sort of at-risk behavior. So it calls into question, we have in the United States the National Practitioner Data Bank. So if there's a malpractice award, it gets listed in there. But sometimes that can lag, and sometimes it doesn't always cross state lines, but it's something important for us to address. In sum, overall, you heard me mention 175 cases. This is out of literally maybe at this point 800,000 cases. So the level of malpractice claims is actually pretty low. If we look at what are risk factors, they were heavier and more often male. Surgeons who had malpractice claims were less often board certified compared to the norm. And I think the big thing for me, I'm a big proponent of accreditation on many different levels, is that the hospitals who had lawsuits had an accreditation rate half of what is national average. We did see that some malabsorptive and, as I mentioned before, non-standard procedures were overrepresented compared to the national norms. And while mortality was the number one reason, the other ones came up, including bleeding, retained foreign body, and vascular injury. It was about half a dozen cases that had vascular injuries, and these involved placement of the OptiView trocar without the benefit of insufflation. In about 6 of those cases, the trocars went into one of the great vessels, either the vena cava or the aorta, and the patient was not able to recover. In summary, we know that the failure to diagnose, delay in treatment, postoperative care, and communication are clearly opportunities for improvement. And here are some things that we learned from it, and it is part of the Patient Safety Committee curriculum that stem from this report. When it comes to technical issues, I already mentioned a little bit about vascular access and being careful with that. There were a few cases of NG tubes being stapled that led to leaks. So in our practice, when we placed a liver retractor, we confirmed there's nothing in the mouth except for the ET tube. We've now started to say the face because the temp probe can be in the nose, and sometimes that can slip down. Hernia management is important. There were more than a few cases where the omentum, which was acting as nature's plug to the hernia, was lysed and then brought down, and then the hernia was exposed. Nature abhors a vacuum, and it must be filled. And so that's what happened with small bowel obstructions. So some other things to work on is some standardized handoffs, as I mentioned. I think the future may include some home monitoring, some sensors. At Yale, we have a pilot that we're doing right now with exactly that. It's a souped-up Fitbit that can also give you temperature. It's called the Philips Health Dot. It can give you temperature, blood pressure, respiration rate, and even glucose levels. We're building into that some cognitive assessments as well. We hope to update this closed claims registry under the leadership of Tony Petrick, and hopefully we'll hear more about it down the road. Really an honor and privilege to present to you today. Thank you all very much.
I'd like to invite the next speaker, Dr. Ramon Villalanga, who's going to talk about practice behavior, but that reduces the likelihood of being sued.
Learning from malpractice.
Oh, I'm sorry. Excuse me. Learning from malpractice in bariatric surgery.
Thank you, Scott, for the kind presentation. And obviously, it's always a privilege to be here in our World Congress, and especially trying to deal with a topic that I'm very concerned as soon as I belong to a council of all the College of Doctors in Barcelona that gets more than 37,000 doctors, and in which every 15 days we need to review issues which are going on related to our colleagues in all specialties, but then I will try to focus on bariatric surgery and what has this council already published so far. So I have no potential specific conflicts of interest. This is my case mix presentations and cases. And just to let you know, there are continuous references to bariatric malpractice in the journals worldwide. And this is something we need to be aware. I think we have had a decrease on that because of the better treatment of the patients, because of the better teams, because of the better multidisciplinary approaches. But definitely it is very important to assess the bariatric surgery as a pure specialty among the general surgery, and how the multidisciplinary teams are now facing even more complex cases. We cannot compare the bariatric surgery we are performing nowadays with the one that was performed 30, 40 years ago, but not because it was not well performed, simply because now maybe there's more knowledge behind, and also probably less. What is the bias on that? The more cases are done. So we still have malpractice going on, and we need, as Dr. Morton said previously, to focus on the topics. Medical errors are serious public health problems and leading cause of death in the United States, but also in Spain, and they need to be recognized when the event occurs, but also learning from them. We need to install the culture of learning from the error. This is not something we have in all the Mediterranean countries, and this is something I blame in my country. And we need to know that these medical errors have also a huge impact also in the same physicians. We have problems sometimes with our residents, with our young fellows, and even with myself, when we can have problems with anger, feeling guilty, inadequacy. Some colleagues can turn to depression. They need to be supported by medical care after complications, and it has really an impact on the system. The medical malpractice and the surgical malpractice also has, obviously, and I think this is the center of the talk, an impact on the patients. Medical malpractice, so, can occur either because the error turns from a result of an action not taken, or because we have denied the action, or we have started the wrong action later on, and this is something that has been already expressed with the database from the United States by my previous colleague, Professor John Morton. So we need to be able to deal with these situations, and we need to learn according to the experience what we have learned from the malpractice. These are examples of medical malpractice, and I think we need to strengthen the one of misdiagnosis, delayed diagnosis, and why not doing an incorrect treatment because probably you come from a delayed diagnosis. The more you think you won't have complications, the more problems you will have. The less you will think this can happen, the more problems you will have. And this is something that your medical practice and your surgical practice with the years will give you. Whenever you think you might have complications, go ahead. Don't stay behind the complications. Always go a step forward with your complications. And this is very important. In this review on the medical legal cases in United Kingdom, that was they showed the postoperative mortality of 0.04 and a complication rate of 2.4, and they showed that was significantly different from the United States. They were related, and they identified almost 600 claims, mainly in gastric bypass, obviously, most performed procedures at that times, of course, but also more complex procedures, introduction of laparoscopy and other things going on that could explain also these claims. But definitely there was an aspect to consider, and it was that there was a significant increase of the number of bariatric procedures. When they analyzed Dr. Cottam in a paper published in 2007, the initial concept of the negligence, the failure to detect the complications in a prompt manner, they saw that most of the causes were intraoperative complications, anastomosis leak, intra-abdominal abscesses, bowel obstructions, but especially they found that the primary procedure had documented any type of complication. So you start your complications with intraoperative complications. So you need to deal with more complex cases, and you need to be aware that maybe a difficult cases will make you be give you more attention in the postoperative care. And this is something also that we can deduce from the literature, in which you need to understand when do the complications come. In this first analysis in 2012 from the Catalan Council from Barcelona, they analyzed that there were nearly 50 cases that underwent during the period of 1992 to 2009 to a legal responsibility. Most of the cases, I would say 47%, were patients that unfortunately died after the bariatric procedures. That's the reason why these cases went up from a legal way to the courts. 21% of the patients could recover, but 32% had a residual impairment. So most of the complications were related to anastomotic leaks, but also to respiratory complications. Malpractice was considered to have occurred in 20%, so this is something interesting, because not always huge complications are related to malpractice. Complications can occur, you can do the best for the patient, but these are complex patients in a complex scenario in terms of complications. And this is something to be related. At that time, there were no accredited centers. And more recently, we reviewed the database, and we did again this database from all the colleges of doctors from the four areas that do the autonomy of Catalonia. In 35 years, there have been more than 10,000 claims. 840 were related to digestive procedures, and 0.86% were related directly to bariatric bypass, included 28 related postoperative death. 30% of the claims in our institution who takes care of the legal issues of our doctors are related to mortality. So the real impact of suing doctors after bariatric surgery is not so high, unless there's a huge complication that is an unfortunate death. The main causes of the defect was the defect on the surgical practice, 60%, and preoperative complications after the procedures, around 40%. The most related, in comparison with the database presented previously by Dr. Morton, is here we had a huge increase of the sleeve gastrectomy in our area, and so most of the suing was related to sleeve gastrectomy, more than gastric bypass, and then there was a residual number of patients of intragastric balloon not functioning, occlusion, but also gastric bypass. Of the 85 closed procedures in the legal way, 67% were without liability for the doctor, and 26 had to pay out. The most, the money that the compensation paid claimed was from 250,000 to 70,000 euros average. I will switch completely this slide, as it has been perfectly explained by Professor Morton, but just to reinforce the idea that we have opportunities to better do the things and improvement in our practice, and this very related to the avoiding the surgical malpractice and the risk of being sued on this. Failure of diagnosis. Always think you have a complications, never think you will never have a complication. Always think you will have a complication. The delay on treatment and postoperative care. Think we need to have very present this. We can control some of the cheese, not all the cheese, but we can control some of the cheese. And this is something, since the last 3-4 years, I try to understand very well. Where can I improve myself and my team in order to avoid easy, avoidable complications? And this is something to deal with that. Preventing surgical errors, as a conclusion, they do not arise spontaneously. Sometimes the errors come after personal errors which are misundertaken or misdiagnosed. They develop from interaction of multiple people and equipment. Important to understand that. Equipment, technology, and team. We're working in a multidisciplinary team, and this is important. So we need to understand our providers, but also our centers. How? To accept that we will have errors, avoid distractions, have very good preoperative knowledge of our patients. This is something also related. Improve our staffing. You can be a good surgeon, but if you are in a wrong OR with the wrong people, you will have a lot of problems, believe me. This is something we have all experienced, and this is very important. Surgical times, adopting the checklist prior, skin incisions, what are we going to do, what are recognition of the patient, recognition of the location, recognition of all the intraoperative. And also we need to standardize our equipment and procedure. Standardization is a must in our specialty. Although it's difficult, we need to try to do always the same thing that works in a correct way. If we have real-time data of our database, we can know a peak of incidence of a problem, and then we can go back to our things that we're doing. We try to record all our surgeries and to review them if necessary. So our institutions need to protect us also. They need to make decisions on technology, so this is very important. This is a huge list that was already published and mentioned before. So this is all the things we have learned, and they have teach us how to prevent malpractice in the bariatrics. In your hospital, we have a huge and strong security commission in which they try to go for very harmful complications. I've been in 2 of them. This is a real session on what we did good, bad, or in an intermediate way, and proposing different strategies to change protocols in our institution. From our society, we even did at a certain time the emergency course for non-doctors treating postoperative, treating patients who underwent previously a bariatric procedure. So you need to train surgeons, you need to do things from the societies. So again, as Dr. Morton said, patient satisfaction. You can be a bad doctor, but you are very sympathetic. You might escape from a law and a suit. And this is like this. Why? Because patients will understand the information. You need to make information reliable, communicate clear, educate. And this is very important to understand how you will deal with all this surgical malpractice. Appropriate consents, careful surgical technique, multidisciplinary involvement of all the team, and in order to reduce and mitigate. And also, I think this is very important in our institutions, is to promote the culture of sharing the error. It's a shame because the surgeons, we are not good at that. We don't do things well, and this is something we don't do well. We always think the error was from someone else. And in the worst of the scenarios, it was the patient. And this is not the culture we need to promote. We need to make sure we grow in a culture of sharing the error in order to discuss in clear and good sessions how we affront for the doctor, but for the team and for the improvement of the future patients that will treat it. So thank you very much for everybody and for your attention. Thank you.
Thank you very much for an excellent presentation. Our next speaker is Dr. Hazem Al-Momani from United Arab Emirates, and his talk will be on practice behavior that reduces the likelihood of being sued. Dr. Hazem, the floor is yours. We cannot hear you. Can you start the mic?
Good afternoon, everyone. Thank you very much. Thank you for the opportunity to share with you my presentation. My name is Hazem from the United Arab Emirates. And my talk today is about practice behaviors to reduce being sued. This is my case mix disclosure slide. A friend of mine spends his weekends going up the plane, thousands of feet, and jumping off his parachute while you and I are sitting in our garden enjoying our pint. And I say, Dan, why do you do it? I say, I do it because of the adrenaline. I enjoy it. And I said, Dan, how do you know that the parachute is always going to work? He said, it's not always going to work. It's going to fail. And that's why I have a second parachute, and that's why I have a third parachute. And I think this applies to what we do in our day-to-day practice. As John has correctly said, the only way of not having a complication, not being sued, is not to practice at all and not do anything. Just give talks and lectures and do something less risky. So We are going to be sued, not because we're intending to hurt our patients, but complications happen, and the human body is not a machine. You do the same operation on 2 patients at the same day, same team, same equipment. One would walk home within 2 days. One would spend 3-4 months in a hospital, jumping from one hole into the other. The cost of medical liability is huge. I was shocked by this figure here. Apparently, the NHS has set aside around £84 billion for the future because they've got a certain number of lawsuits in the pipeline that they believe they're going to be settled over the next few years. This is only second to the cost of decommissioning the nuclear plants in the United Kingdom. And according to figures published by the US Department of Health, the cost of compensation between the years 1990 and the years 2020 is in the excess of $151 billion. Our specialty is amongst the highest sued specialty. Our specialty is a specialty with the highest compensation rate. So our specialty is amongst the specialty that's most likely to go to court or be settled out of court, and it's one of the most costliest of specialties. And I think there are various factors related to that, perhaps because of the volume, because of the complexity of the patients, the likelihood of when it goes bad, it goes terribly bad with the patients undergoing bariatric surgery, contrary to other procedures, for example. This topic becomes quite important, especially in bariatric surgery, because in my part of the world, a lot of the surgeons travel from one country to the other. And there is no one set rule for every country. There is no one set rule for every state. So the first tip I share is know your laws. Know the law of the land. If you're practicing in Kuwait, if you're practicing in the US, and you've got a practice on the side in a third country, what applies in Kuwait will not necessarily apply in my hospital and will not necessarily apply in your hospital. So always familiarize yourself with the laws of the land and always work underneath the law. What you're allowed to do as a procedure in one country and be considered acceptable could be completely wrong and negligent in another country. So always be familiar with that. Make sure that when you go to start your practice in any hospital, that all your paperwork from a hospital point of view is up to scratch. Don't be tempted by the offer of a good revenue, come and do your surgeries, we'll look after your patients, because when it goes wrong, it's your neck on the line, not the management neck. And at the end of the day, a harm had come to a patient. And if that patient or their family would come to know that you have deviated the standard of practice, you're at fault. Stick to what you know. I've been to a couple of events where I've heard colleagues standing on the podium proudly saying that I've watched a video on YouTube the night before the operation and I went and do it. Unfortunately, in this day and age, this is unacceptable despite being practiced. If you're not sure what you're doing, make sure you're competent at it. Ask for proctorship, ask for training, and always back up everything you do by evidence that you're competent, have been trained, and have shown a track record or have got a certificate to show that you're capable of doing it. If you don't know how to do it, you shouldn't be doing it. And there's nothing wrong with saying, I don't know, and seeking help and training by others. I mean, our society is quite small. You look around the room, you walk down, and by the time you walk from one pavilion to the other, you've met around 100 people that you know, or at least you know their face. And with social media, with the way we communicate, it's easy. You can drop your question on platforms and you've got colleagues from all over the world giving you insight and input into the management. Keep your knowledge up to date, attend such events, look at the recent publications. The practice I did 5 years ago could be obsolete in 5 years' time and vice versa. Make sure that you've got a medical liability in place. Nowadays, a lot of insurance companies will offer you an international policy to cover your practice if you're traveling. In some countries, your hospital will sort that out. In others, you'll have to sort out your own practice. Make sure you know and you are covered, because it's only a matter of time because you'll be before you're standing in front of a judge or whatever it is in your place. So this is something quite important. Build a good relationship with your patients. In my part of the world, this is what it boils down to. At the end of the day, we're all humans. We like to be treated with respect, and we are more likely to be tolerant when it's come from someone that we trust, we respect, and we believe that whatever had happened because things were not meant to go to plan, not because they were not doing a good job. Be respectful, be open, and be genuine and legitimate with your patients. And always, always make sure to involve your patient in the decision making. Make sure they're comfortable. And again, in some cultures like mine, sometimes you need to involve the partner. And this is very important. And I always say, a patient on a ventilator in the ICU is not going to complain. It's going to be the family. It's going to be their next of kin, their relatives. And this is why you need to keep everyone involved and build a relationship with them. I understand we have a busy practice. Patients do understand that as well. But being legitimate, being genuine with the patient can avoid problems. Communicate clearly, whether it's via electronic methods, whether it's verbal, whether through videos, through links. Make sure you communicate and have written and visual communication. And always, always have an expiry date on your communication material. You need to review it on a regular basis because, as I said, the evidence is evolving. New procedures are dying. Old procedures are dying. New procedures are emerging. And the guidelines keep changing every now and then. So make sure that. And, as I said, give room for question. It's no longer a one-way communication, it's a two-way communication. A patient and a family involved in the decision-making are more tolerant should things not go to plan, especially when dealing with complex high-risk cases. This is very important. And build a good relationship with colleagues, because they're the one who's going to help you. Because once the dice have been rolled, you lose your insight. You're looking down a narrow tunnel. Seek help. They've seen it. They look at it from a different perspective. They're not emotionally involved. Ego has been put aside. Always build a good relationship. You might not like them on a personal level, but at the end of the day, we're all professionals, and there's a human being at the other end of this affair. And this is very, very important. And I find it really sad in some of the places I've worked with where you're on your own and you'd refuse a job offer to work in a very decent, reputable institute, but the atmosphere is not a healthy one. And you know you're there watching your back from colleagues and knowing that when the cards fall, everyone is out on your own. It's very, very important. And nowadays, our specialty is amongst the most diverse and multidisciplinary specialty I've come across. You've got interventional radiologists, gastroenterologists, dietitians, psychiatrists, psychologists, all of them involved. Build a good team around you because you will need them. Document, document, document. Not documented, not happened. Always make sure you document legibly, in a timely manner, and be up to date. Should you forget to document something, write it in retrospect and make sure that you've documented the fact that you've documented it in the retrospect matter. And most importantly is the final point. Sometimes you might have remembered something or you realize you've done it wrongly. Never alter medical records. That could be considered forgery. If you believe you've documented it wrongly, refer to it later and said that this is what had happened. And in every hospital, in every system, there is a policy when it comes to amending medical records. Make sure you stick to that policy, and that will get you into a lot of trouble. And then you've got the electronic medical records. Where I practice, we're a paperless hospital. Everything is electronic. Everything is templated. And it's very easy to have a template for post-op patient, pre-op patient, pharmacotherapy patient, and you accidentally click the wrong template and you've got an entirely wrong documentation for the wrong patient. So be careful. Be careful. Check, and double check because it's very easy. Copy, paste, copy, paste. You get a patient coming for a sleeve gastrectomy, male patient, and then your documentation is a 45-year-old lady, para 7, whatever, last period was 6 months ago, whatever. Always be careful. Been there, done that. In the NHS, we rely a lot on stickers, and you can end up putting the wrong sticker on the wrong request, and that can get you into a lot of trouble. Park your ego aside. At the end of the day, there's a human being at the end of this affair. And if you believe that you've come to the limits of your abilities, whether mentally, physically, from a knowledge or skill size, always get someone to help you there. Seek legal advice. Every hospital, I've got a legal team. Make sure to approach them early on if you believe there's a case that might escalate into a lawsuit. They will guide you and they will advise you and they will make your life much easier. And there's nothing wrong with asking for their help. And always be prepared to apologize. I think sincerity is what makes the difference. That doesn't mean you're not going to be sued. That doesn't mean a compensation is not going to happen. But if you get forgiveness from your patient. It will help you as well accept what had happened, and this is very, very important. In some US states, your apology could not be held against you should a case be taken to court. So be open. If you believe there was a genuine mistake and you're comfortable doing so, I would encourage you to do so as well. Reflect on your experience. This is where you show your professionalism. Share your experience, share your mistakes, discuss them in your departmental MDT, your hospital MDT. If there's something worth sharing on the podium, do so. If there's something worth sharing in a publication, do so. This shows a mature, reflective behavior of an individual who's willing to learn from their misadventures or mistakes or whatever unhappy experiences they've encountered. This is very important. And most importantly as well, at the end of the day, for that patient, it's the one problem. For you, you're going to walk away from that encounter and engage in 5, 6, 7, 8 encounters later that day. Look after yourself. Look after your team. A lot of people could be suffering in silence. Reflect on this experience. Sit with your team. Discuss with them what had happened. Listen to them. If you believe any of them would need support that you're unable to, refer them to the right individual. And this is very, very important. Make every opportunity a learning opportunity. Turn it into a positive one, at least from a practice point of view. At the end of the day, we walk away from one complication to deal with another patient who would expect you to be fresh and ready to deal with their problem. And unless we look after ourselves physically and mentally, we won't be able to do a good job and look after our future patient. I believe this brings my talk to an end. Thank you ever so much for being such a nice audience. Thank you.
Last paper of the session, New Technologies, Procedures, and Medical Liability by Eric Wilson, USA.
Thank you. It's an honor to be speaking with so many esteemed colleagues and great friends. Let me get my slides up. I know we're getting towards the end of the session, so we'll try to wrap it up quickly. These are my disclosures as it relates to I've done a lot of research and I do a lot of teaching, both with industry, and I also have a large fellowship I'll talk about. But one disclosure I'd say is I'm lucky as it relates to malpractice because I work in a state institution in Texas. And Texas is a state that has liability cap for non-economic damages. So it gives the amount of pressure that's put on us is better than average. So I don't know if that created an environment where it's easier for me to focus on innovation, but I think it's worth knowing and disclosing. I am a guy that believes in a lot of innovation. I am an academic surgeon, but I've been accessed in the Texas Medical Center to a lot of technology that was freely available to me, and so we ended up doing lots of robotics and endoluminal procedures, both pilot and pivotal trials, FDA approval trials, built a large research team, also trained fellows, so had to do a lot of teaching of fellows, which when you're adopting new technology, you need to understand how you're going to learn it and also teach it, and also built a training center where people would come in and learn new procedures. I enjoy procedure development. It's something that makes me very excited. And I think you have to be a contrarian by nature to champion something that's not generally considered approved. And that makes you stubborn, but you also have to recognize your weaknesses. And I think that's very important as it relates to when you're learning something new and you're trying to do it in a safe way. You cannot go through innovation and have a bunch of bodies on the floor as you're trying to do something new. You've got to acknowledge that you've got to figure out a way to do this safely. Some of the major innovations over the years, such as liver transplant and stuff like that, there were a whole bunch of bodies on the floor in order to create that. You can't do that in this modern era. It's just not allowed. So you have to figure out how you're going to learn. And one of the things that helped me was learning how to teach and teaching a lot of people how to learn bariatric surgery and minimally invasive surgery. And we've trained a lot of fellows over the last many years. And we also have a training facility that we have lots of teams coming in and learning procedures. That combined with participating in running meetings that embrace innovation and technology make you come up with some questions. Is if you're going to look at doing something innovative, what really makes a safe surgeon. And I think a lot of the speakers already today have talked about this, maybe not in a direct effect, but we classically talk about, well, that person's got good hands or that person's got good hands. But really what it boils down to, and I think the take-home message of today is it's really making the right decisions at the right time. That really at every given moment during a procedure, are you making the right decision at the right time? You've got to understand your tissue that you're manipulating and how it works, and you've got to be aware of being able to troubleshoot the anatomy and also troubleshooting the device. You've got to understand the device and understand the engineering of the device. If it's a new device you've not had in your hands before, you want to spend as much time learning how that device works itself as you're learning how to use it in a patient. These two things, learning the anatomy and what anatomy you're going to be working on with this new device, and then learning how the device works or how you do this procedure with a new device, that is critical, and it applies directly to the performance of new procedures. So, you can do multiple things to learn new surgical skills. You can use simulators of various types for basic moves, more advanced simulation, and tissue models, both alive and non-alive, to learn more complex moves. And obviously you can spend a lot of time in the OR with an expert. And you need a teacher. If you're going to learn something new, you've got to be willing to be a learner, and you've got to find a teacher, and you've got to learn from them, and you've got to work on every step of the operation with that device. And all surgery basically comes down to how are you going to expose it, how are you going to retract it, how are you going to provide traction, counter traction, and then what are you going to do in the middle. And that's how you create dissection, and that's how you create reconstruction. So using like robotics as an example, I have one standard way that I teach people to do all foregut surgery. Well, is it the best way to do all foregut surgery? No, it's not the most efficient. It's reproducible, and it's something that people can learn, and they can teach other people, and then they can adopt off of that and get more efficient, but they learn something that's safe and doable. If you have a approach that will work with the top 10% of people, and yet they get extremely frustrated because there's so much variability they don't know how to manage, then you start having lots of problems. In robotics, we have evolved, and I think we're going to be dealing with this more as new robots come onto the market, but we used to do a lot of hybrid procedures. There was nothing wrong with doing hybrid procedures. Using laparoscopy, using your skill sets that you know with your known instruments as you're learning how to utilize a new skill set with new instruments, and we need to rely upon that. So combined laparoscopy with endoscopy, you're doing something new endoscopically, use your laparoscopic skill set when it makes sense and you're unsure of what you can do endoscopically. When you're doing something robotically and you're not sure whether you're able to safely perform it, use your laparoscopic skill set. This just requires a lot of insight of what's going on while you're doing the procedure, and having a plan up front. We used to train surgeons that were learning robotic surgery for years of just start with the gastrojejunostomy, or just start with a few sutures of the gastrojejunostomy. Use what works for you, and we'll adopt off of that. Start with more simple procedures if you can, but some devices are for a specific type of procedure. But utilize your known skill sets to help you with those acquiring of the unknown skill sets. With robotics, for example, you can assist and learn and teach in multiple different approaches. You can be at the console, you can be at the bedside, you can both be at the console, you can both be at the bedside if you need to be. So you've got to figure out what role you're supposed to be in when you're learning something, and those roles will evolve as you get more comfortable with utilizing the new technology. So when I take our fellows through an anastomosis, I have them look at the specific components of the procedure, learn the specific components of the procedure, and then I hand, even just an anastomosis, specific components of the anastomosis to them at various different times. There'll be times where they're working on the back row. The easiest thing to teach them is the anterior outer row. Then the second thing that's easiest to teach them is the posterior outer row. Then the third easiest thing is the anterior inner row. And the hardest thing is the posterior inner row. So I give them time to say, this is what we're going to work on. I give them graduated autonomy. I say, I want you to do exactly my way. This is exactly what you need to go through when you're learning something new. You need to be honest with yourself and your skill set and divide up the procedure. And you can use, if you don't have an expert there all the time, you can utilize the skill set that works. Utilize laparoscopy. The first time I did a robotic case in 2002, I docked the robot, did 2 stitches and stopped because I was like, I wasn't comfortable. You've got to stay comfortable if you're going to make good decisions. So informed consent. I think it's really, really important when it comes to new procedures. You've got to be able to tell your patient that you're doing a new procedure. And you should be able to say, look, I trained on this procedure for this many hours. I worked with this surgeon who taught me this, or this endoscopist. I have done this number of procedures. How many procedures have you done on humans? I've done procedures with proctoring for this number of procedures. I've done in the lab this number of procedures. I assisted with these number of procedures. If you provide that information to the patient, they'll understand that you're coming at this with a sincere, honest, and measured approach to try to drive something new into their care. You give them a reason why you feel like this technology has a potential advantage. And we don't always have level 1 data when we start doing something new. So we have to tell the patient, here's the potential things I think I can help. But this is the skill set I have in case I can't safely do it. And this is what I'll rely upon if something's not working. And I'm not going to be wedded to this for that entire procedure if it's not safe and I can't do it effectively. So I have a standard approach I can use without this technology. I think this technology could help me in this situation, so I'm going to offer it. But if it's not proceeding well, we'll go back to what works in a standard manner, and you need to inform the patient of all of that. And also you want to tell them, look, if I do not feel it's safe, we're gonna not use it, and we're gonna do what we know works. So to summarize, I think technology obviously is going to continue to drive minimally invasive surgery, and we must learn how to adopt it, but we've got to learn how to adopt it safely. Surgery above all is about good judgment. It's not just the tool you're using, but how you're using it and how you're learning to use it. The best protection for adopting new technology is good informed consent for your patients, a well-informed patient, just like it is for revolutionary or evolutionary procedures, stuff that we've had in our armamentarium for a long period of time, and continual insight, which I know I misspelled, I'm sorry, I'm from Texas, into your skill set to the technology along your entire learning curve. So you have to be constantly thinking about, okay, where am I at? What do I need to improve? And it's just a constant self-reflection if you're going to be successful when you're adopting new technology. And of course, obviously, it's been stated over and over again by all the speakers, the best defense for malpractice is a safe outcome with a well-informed patient. So thank you very much.
Thank you, Dr. Eric Wilson, for an excellent presentation and talk. We have a few minutes for a couple of questions from the audience. Please feel free to ask questions for all speakers.
Hi, this is Francesco Carrano from Milan, Italy. Amazing presentation to all the speakers, amazing. I was wondering whether any of the speakers today think that the media has any role in increasing or decreasing the number of malpractice lawsuits, or has any role to do with that?
So any of the speakers would like to handle this question, please feel free.
Thank you, Francesco. Definitely, there's no data related directly on the number of cases in the media, in the public media, but this is not referred in the literature. What we know is that it used to be a trend, and now the cases that are more anecdotal compared. If you see the proportion of the number of bariatric cases that are done currently worldwide, the number of cases that appear in the medias are very low. this is the explanation we have now. I don't know if Eric wants to add anything. You have the same feeling?
Yeah, I totally agree. Don't have a lot of experience of that, and I think there needs to be more data collected in that area. But it would make sense that it would certainly shine lights on things. I have seen locally when you're doing something new and you decide to put it in the paper and the patient has then a bad outcome, that often ends up in the paper. So you've got to be careful about, when you're doing a new procedure, making sure that you're not there to brag about it as being the guy doing the new procedure, but getting the procedure done well. And it's generally a good idea to wait until you're many months into your learning curve, have well-established outcomes before you start bragging about how good you are at this new procedure.
This is somehow related to the new surgeons on the medias and all the communication platforms that we have now, and this is very dangerous. It can affect you as a boomerang, but usually the hospitals nowadays, they have a very strict communication policy, and usually when these are primer or novel cases, they make sure there's obviously an agreement to communicate the case in the medias, but also that the patient obviously is good.
Very quickly. So I'm Julie Parrott from somewhere in the US. Anyway, excellent presentation. I really applaud you. Thank you so much. And since it was brought up about B1, I just and the question about the media, the reason I really was into that with my earlier presentation, I was astounded looking at the media. So looking at some of the advertisements that law firms are doing in the US, the way that they are advertising to patients, they are educating the patients better about B1 deficiency, Wernicke's encephalopathy better and more thorough than many of our own practitioners in the US. I found that almost appalling.
I have one comment, a general comment about the media. They like to publish negatives. They don't like to publish positives. So to, say the same thing that's been said, don't think that the media is your friend. If you've screwed up, they're right there.
Okay, yeah, this is about new procedures. I know nowadays a lot of new procedures are supported by the industries, basically who make them. And they also come with the standards and these many hours, but there isn't any such a guideline for the regarded associations available at the moment. How much it would stand in the court of law if something goes wrong? Would that meeting the industry set standards would be suffice, or is it because it's how it is interpreted is different, isn't it?
Yes, absolutely. So meeting those standards set by the industry, and the FDA, for example, in the United States, the FDA has put more pressure. Although they claim they're not a training body, they want to see training pathways with new innovation. So those standards do have some rigor to them, but it doesn't necessarily protect you. So I think you should take the rigor that the standards that the industry has created with the approval process, wherever it is, and use those as a bar minimum, but not consider them the ultimate standard. And I don't think you can use just a defense of, well, I did everything that they said I need to do. That's not going to be an acceptable defense if you have a bad outcome in and of itself. It certainly helps that you did it, but you should look at okay, is this safe for me? Not necessarily is this safe for some general standard. What's safe for me and what's safe for my patients? And that's where it gets back to looking at yourself when you're trying to adopt these new procedures.
Yes, thanks.
With all the presentations covering all these topics, first of all, you mentioned about the media and public. There's the old saying, don't bring ink to a knife fight. And you can't win, and they twist your words if it suits them. So be careful what you say. Maybe don't say anything to them without your attorney, which brings me to my second point. We had a course like this in the United States a few months ago, and the lawyers really made a big point. Shut up. Don't say anything. Every word you say gives the other side an opportunity to twist it and throw it back at you. So without your attorney present, don't ever speak to anybody, no matter what. And I want to go one step further and ask Eric, actually, put you on the spot. Do you videotape your cases?
Yes, so I have a big group. Some of us do video, some do not. We do not always agree about it. I personally do because I'm teaching and utilize it for teaching purposes and video review. And I think there's a lot of quality improvement that can be had out of video review. There's obviously lots of concern about what is that discoverable or not, and there's still debate in the United States, and it depends upon your area in the United States, not even agree upon from state to state. How much of that is discoverable? If you ever get in a lawsuit, they'll often ask, do you have a video of it? And sometimes it's protected, sometimes it's not. If you have a video, it actually can help you as much as it can hurt you. It just depends upon what's in the video and how it looks. There are times a video can be helpful, but it's a calculated thought process as to whether you want to video or not. I personally do.
You're teaching, and you brought that out, but what would you suggest to somebody just in private practice about videotaping their cases, not for teaching, but to have a record of what they did?
I have mixed feelings about it. I don't have a great answer for you, Scott. I can certainly see both sides of the argument. I think personally, as a surgeon that wants to continue to improve, I like the concept of having video and being able to go and look at it. And there's been lots of organizations, collaboratives where they look at video review, and it's driven better surgical outcomes. So yes, there's some potential litigation risk of that, but at the same time, there's so much that we can learn off of analysis of video that I think it's worth it. Yeah,
I was trying to make the point that there's two sides and there's no right answer. Both attorneys, senior attorneys, defense attorneys that were at this course, both very strongly said, do not tape your cases ever, except for maybe education. Because they can take your tape, it could have been a perfect case, they'll find some expert out there who's going to find something wrong with part of the video, and then you're stuck because you got the video, you can't deny it, you can't
Well, and that gets back to my disclosure originally. I live in the state of Texas. It's harder for me to get sued than it is for Scott. So you get different advice depending on, you got to know your environment too. But I do feel you learn a lot from looking at video.
Sure.
Where we practice, Scott, we tend to record for training from a registration point of view or documentation point of view. But one of the challenges we've got in the Middle East is that the standards of some of the equipments being used cannot be 100% always guaranteed. We've got a lot of products that we use that could be brought out as knocked out, brought out through a black market or parallel import, where you cannot control the quality. And you'd need a way to prove that whatever had happened has happened because of an error from the instrument. And I know it's not the right way to say it, but in a way it wasn't a problem from the surgeon or a defect from the surgeon. It's the hospital, the company that brought them, and the equipment. And like yourself, we find it very, very useful having the videos. And again, I think our legal system where we practice is probably not as aggressive and mature as where you do.
I was going to ask about the video, so I'll upgrade it to an AI question. Are there any candidates for clinical decision support based on video that you think would be likely in the next 5 to 10 years?
There are a lot. Now, it's interesting, the companies, because a lot of them are using video and AI analysis of video. One of the things they're doing with hospitals, because of concerns about long-term control over that video, is they're creating contracts with hospitals where they will only access and hold the video. Now they may collect information off of the video that's not the video itself, but the video gets obliterated off of all their servers at 1 month at 30 days. So that's one of the things that are making hospitals more comfortable with some of this AI. There are hospitals that after they get involved, they're like, we want you to keep the video so we can have access to it long term. There's a whole bunch of companies, theater, SSI, a whole bunch of companies that are developing AI products. They're not quite at the point where their products are real-time live feedback. That is a big goal, but we will definitely see that in the next several years. Yeah.
I want to poll the audience. I want to know how many of you are in favor of a surgeon doing expert plaintiff work versus defense work in malpractice suits. No. You're just, a lawyer calls you up and says, I have a case, a woman had a gastric bypass, leaked and died. I think the surgeon did something wrong. Would you look the records over? Who would take on a plaintiff case? About half. Yeah, I'm not judging because occasionally
What about you,
I
Scott?
do.
Would you do a plaintiff's case? I did one, and I just felt so awful at the end of it.
I would rather...
It was an obvious malpractice case, and it settled and stuff, but it was just, talking with the lawyers, it just was very, very
I do
unsettling.
From time to time, but before I say yes, I want to know about the case because some of them are frivolous. I want to know that it sounds like a reasonable case. I don't want to know who the operating surgeon was, so if it is somebody I know, I'm out. And I look the case over to try to help the surgeon, not to screw the surgeon. Who better to judge whether the surgeon did something right or wrong than another surgeon as opposed to a retired gynecologist? So you'd rather, if you were being sued, have me look it over because I may very well say there's absolutely nothing here and cut a break for you than the other side.
That's a good point. Very good point.
Yeah, so Scott, in answer to your question, in the UK, I'm a medical legal practitioner. I'm a bariatric surgeon. And I think we're all encouraged to strike a position of equipoise because when we write up the report, our duty our duty is to the court, not to the plaintiff or the defendant or the lawyer who is advising us to take on the case. So we are encouraged to have that equipoise, and we will be challenged if we say quote evidence to support or to say that there is no case to answer if we are found not to be altruistic about it. So from that point of view, I personally I'm in the field mainly to sort of, I don't know how much you guys believe me, but to protect our corner rather than allow sort of frivolous complaints to come through. And I must say, I've been doing this for the last 3 or 4 years. It has informed me so much in my own practice regarding learning from mistakes which happen. And I think I would encourage all my colleagues to get involved with this because if you have got to stop the rot of frivolous complaints being launched, I think we should then get into the ring and try to take the responsibility. That's my take.
Excellent. Thank you.
Right. Thank you very much. Okay, last question before we end.
I am a psychologist. I'm sorry for my English, but Momami, what do you think about signing consent as part of the pre-bariatric psychological protocol?
I don't understand that.
So the question is, what's the role of preoperative psychology assessment, right? So maybe we can ask if anybody from the speakers could take this question. If you ask me, I'll say it's important, but it depends on the case. In our institutions, we do that case by case, but maybe other institutions does it as a routine. Maybe what?
As a routine, all the patients go to the psychologist's psychiatric preparative evaluation, either adding treatment. So any comment or any objection to the process of possible bariatric surgery has to be recorded in the medical history of the patient. And this is where, in some way, the psychologist is allowed or allows his opinion on the case, saying maybe this patient needs some behavior changes, so I suggest this treatment preparatively and things like that. We have an overall bariatric process or obesity treatment process, consent, in which the patient needs to consent that he will go to your outpatient clinic, our patient clinic, the endocrinologist, that will have to do some follow-ups, that they will have to go through blood samples after the bariatric surgery, and this is a more general consent. We don't have a specific psychological consent on accepting or not the deal of the bariatric surgery, but in fact it is implicit as a checklist before going to bariatric surgery. You cannot go to bariatric surgery unless there's an approval of a psychologist or psychiatric in our department.
Thank you very
You're
much.
welcome.
So I would like to take this opportunity. Yes, go ahead.
When we started bariatric surgery a long, long time ago, it was the insurance companies that made psychological evaluations part of their approval process. And I think that's a very wrong approach, because it immediately says that obesity is a psychological disease. It's gluttony. It's a terrible habit. And it doesn't say obesity is a disease. I mean, it takes away the onus. And I fought that many times in my early days in bariatric surgery, saying, if I have a patient who has a colon cancer, I don't have to get a psychological assessment to operate on the patient. But if the patient with a colon cancer has a psychological problem, I will get a psychiatrist, psychologist to see him. And it should be the same thing for a patient who has the disease of obesity. They may need to see a psychiatrist before surgery, but they may not. And I think if we condone this practice, it's antithetical to our basic premise that obesity is a disease, and we're treating a metabolic disease with metabolic surgery. Now, at the same time, a psychologist as part of your group is an excellent thing, because post-operatively, these patients often have great problems in what they look like and where they're going and should they have done this. And I think a psychologist as an aid to a bariatric organization is a good idea. But to have it as a prelim to getting prior approval, I think it's a bad mistake.
Thank you, Dr. Buchwald, for your comment. So I'd like to end the session. I'd like to thank all the audience, speakers, and moderators for this excellent session. See you next year.
Recording stopped.